This meeting is being recorded for the benefit of your classmates who couldn't be here. Our topic this week is contracts in the electronics age. It's hard to believe that this is week 5 of a 5.5 week course. I can't believe I've known you all for so long. And class is going to end on Tuesday. So next week is a very short week. And so we won't be meeting again. This is our last live session in real time. I'll just post a video of a previous live session for Module 6 so that you'll have a quiz review, in that video. And I'll post the video on Sunday. So you'll have Sunday, Monday, and Tuesday at least to watch the live session video for Module 6, study, take the quiz, and do your assignment. Okay, so let's talk about what's happening this week in the course. Okay, we're going to look at some of the research requirements to form a contract remotely using computers and other electronic devices. Has anyone ever formed an electronic contract? Trina or Stormy, have you ever done an e-contract?
Yeah, I have.
What was it?
When I bought my car,
Awesome.
that was all done electronically.
That is so cool.
I actually talked to a human once the entire time I went through the process, and my car got delivered to my house. It's
Boy,
perfect.
that's all, I mean, it takes away all the haggling.
Everything, everything. It was amazing.
I need to try that because I bought my last several cars from the same Ford dealership and they're all about the haggling. So
Mm.
if I could do that electronically, I could get rid of that haggling.
Oh yeah, you talk to a human one time just to go over the insurance stuff, and then you're all set.
That is so cool.
Mhm.
So yeah, what I've noticed is the last few years when I've lived in apartments, all of the leases were done electronically. You had to sign things electronically. Here at Rasmussen, our teachers' contracts are all electronic. We go into a website and we read the contract and we sign it electronically. So e-contracts really facilitate a lot of things. You don't have to worry about distance anymore. As far as social distancing and everyone being at home, e-contracts are just perfect. So it's a good thing that the technology is already there, now that more of us are working from home and we're working and taking classes online. The technology is already there for us to enter into contracts electronically. So one of the problems though is sometimes the seller will put disclaimers and use boilerplate language when you're signing something. For example, if you buy a computer online, there could be terms that are at the very bottom. And when you buy it at the end, it says, click here to agree to these terms, and you can't even read it. But it's usually, telling you that, warranties are disclaimed and you have to arbitrate any disputes involving, the breach of contract or the computer not working, or you have to send it back to Dell if it has a problem. And so sometimes it's very difficult to understand what the contract terms are when you're forming a contract electronically. Sometimes contracts are formed by emails, people sending emails back and forth, suppliers, buyers, they talk about what it is that they need. For example, a construction project may need 10,000 nails, and they talk back and forth in an email or even a fax. And the question is has a contract been formed? And then what are the terms of the contract? So let's talk about unenforceable agreements. We've talked about the requirements for a valid contract, and that's offer, acceptance, and consideration. However, a valid contract will not be enforced if, for example, one of the contracting party lacks the capacity to contract. And it usually depends on a certain age. If someone is young, if they're a child, then they don't really have the capacity to contract or understand the implications of their behavior. They may not realize that when they're talking to someone that they're entering into a contract. Some people, due to mental insanity, mental incapacity, or even voluntary intoxication, may render it so that someone does not have the intent to form that meeting of the minds that is necessary to create an enforceable agreement. So what would happen in a situation like that? For example, if a child was to buy a Corvette, okay, from the Chevy dealership, and the child gets the car home and tells his parents, you got to pay for this new Corvette that I bought myself. And the parents are like, you better take that car back, son. Um, In that instance, it might be that that Chevy, the dealership, would not be able to enforce that agreement because the contracting party was a child. In the law, they say infant for anyone that's under the age of 18. So that child would not have the capacity to contract. The exception would be for necessaries. If children are buying like food and shelter, those contracts can be enforceable even though it is a minor that's contracting for the purchase of food, necessaries, clothing, food, shelter. But other than that, if a minor tries to buy, like a vehicle and they lack the capacity to contract, their parents would be able to that contract would be voidable and unenforceable. So the law generally presumes that parties do have the capacity to contract. However, certain parties lack that capacity. Like we said, minors, people who have been adjudicated mentally insane, and those who were intoxicated, involuntary intoxication, or voluntary. The common law contracts and then states have also codified that in their statutes, protect persons who lack contractual capacity from having the contract enforced. So it would be unenforceable. The party asserting incapacity or his or her guardian, conservator, parent bears the burden of proving the incapacity. So you just want to understand how the law treats the insane. There is a disaffirmance of contracts based on legal insanity. And the disaffirmance rule is that if someone has already been adjudged insane, the contract is void from the beginning. Neither party can enforce it. However, if someone is mentally incapacitated, but they have not been formally adjudged insane, then the contract is voidable by the insane person. The competent person can't go to court and say, I want to void the contract, because the court is saying, no, you have the mental capacity, but it was Joe over here who's insane. Joe is the one who has the right to assert the contract was unenforceable. So does that make sense, Stormy?
Yes, it
If
does.
the person who lacks the capacity is the one who has the ability to raise the defense and have the contract disaffirmed, rendered unenforceable. However, if someone has been already adjudicated insane, that's by a judicial interpretation. A judge has looked at the evidence and determined the person is mentally insane. The contract is void from the beginning. No one can enforce it. Okay, intoxicated persons. I'm sure you've seen intoxicated persons in bars, and people joke around and say, oh man, I'd like to sell you my boat for $5 because I'm so sick of taking care of it. Would that be a valid offer, Stormy? If the drunk guy sitting next to you at the bar says, I want to sell you my boat for $5 because I'm so sick of taking care of it. Is that a
No, that would not be an enforceable contract because of his intoxication or
good?
incapacity.
Intoxication may occur because of alcohol and these days drugs, right? Have you all heard about this? Fentanyl. People are now overdosing on fentanyl. The drug dealers are cutting narcotics like cocaine and heroin. They're cutting, and opioids. People are trying to buy opioids and controlled substances illegally, but sadly the drug dealers are cutting it with fentanyl, and fentanyl is like 100 times stronger than say morphine. So the person doesn't realize. Two actors came out here to Las Vegas, I guess, for a fun weekend, and instead of bringing their drugs with them, they purchased the drugs here, and they didn't know the drug dealer. The drug dealer cut the drugs with fentanyl, and the both people died. A girl in Connecticut recently died. She was 13 years old. She had fentanyl. They had shit enough fentanyl in there, like 13,000 tablets, or enough to be a dealer. So it's very terrible, that we're living in a time like this where people are abusing drugs and alcohol. Driving under the influence of alcohol or drugs is still illegal, and a contract for the sale of drugs is void. So let's talk about legality. One requirement to have an enforceable contract is that the object of the contract must be lawful. Most contracts that ordinary individuals and businesses enter into are lawful. Contract for the sale of goods, services, purchasing real property, purchasing intangible rights like stocks and bonds, and purchasing patent rights, and purchasing the right to use licensing copyrighted material and software, leasing goods. That stuff is all legal, but some contracts have illegal objects. One example of an illegal object would be it could be a payday loan. If somebody goes and gets a payday loan and the lender chooses to charge an interest rate of 1,000%, that violates the state usury laws. That contract is illegal from the beginning. Neither party can enforce it. What do you think would be an example of an illegal contract, Trina? Some of these are on criminal reenactment TV shows. What if the husband hires a shooter to kill his wife? So, Trina, we're looking at contracts that would be illegal. What if a husband puts out a contract for hire for somebody to shoot his wife because he wants the insurance money, or he's mad at her for having another affair? Would that be legal or illegal? A contract for hire? What do you think, Stormy?
That would be illegal.
Contracts for hire are illegal. Somebody, and sadly it happens, enough that it's an issue in the law, and you will see it in criminal reenactment TV shows and court TV, when the husband has gotten sick of his wife, but he doesn't have the means, or it's not convenient for him to shoot her. He will hire a professional hitman, $10,000, to take out his wife, and then either he can get the insurance money, or he can run off with his secretary or whatever, have the affair, whatever his wife is blocking that he wants. So contracts for hire are illegal. Contracts for the sale of drugs are illegal, except for the states that have legalized drugs. Does anyone know which states have decriminalized marijuana?
My state has
What state is that?
Massachusetts.
Okay. Okay. So we're living in it. So Massachusetts has decriminalized possession of marijuana. But what happens if somebody sells marijuana, if they're dealing it?
Yeah, you can't do that. It's all mandated. I mean, it's all governed by taxes and what have you. There's dispensaries up here, and it's a pretty pricey thing if you know what I mean. Because obviously the federal government wants to take plenty of it if they're going to make it legal. So they must be doing great, but just on the streets, nope, not legal.
Exactly. So yeah, under federal law, the Federal Controlled Substances Act, marijuana, heroin, those are still classified as illegal drugs. So some states, in our complex legal system, states do have certain rights to govern in certain areas. Like here in Nevada, marijuana has been legalized, and people are allowed to purchase it in dispensaries. However, driving under the influence is still illegal. Driving under the influence of marijuana is illegal. But yeah, purchasing drugs from a drug dealer would be an example of an illegal contract.
Right. And it's
Um,
still illegal. You can't just stand out on the street and smoke it either.
you can, I think, in Colorado,
Yeah, in
and
Colorado you can. They have all those coffee shops there.
you can smoke it publicly here in Nevada too.
Really? I don't
Hmm.
know. Maybe you can here. I don't know.
But it's very rare, though. It's the exception. Most states you cannot publicly. You have to do it in your house, personal use.
Yeah, because I would think it would be the same thing as like open containers in public of alcohol.
Yes.
You can't do that still, even though alcohol is not illegal.
Exactly. Exactly. So yeah, that's where when it comes to contract illegality, you've raised an interesting point, Stormy. You will have to know the law in your state, the state where you're working as a paralegal, because the law of what is illegal here in Nevada is different than what is illegal in Massachusetts. So you will have to look up the law in your state to find out what the illegal contracts are. Okay, great. Illegal bargains, contract to perform activities that are prohibited by law are illegal. Contract to kidnap, usury, that's high interest rates that exceed what the state law allows. Contracts that violate public policy. An example of that would be a covenant not to compete. So a lot of times, this happens a lot in the medical profession. Once doctors join a medical practice group, they sign a covenant not to compete by not starting their own separate medical practice that would compete with the medical group that they're working for. And that happens a lot in various industries. So part of an employment contract might include a covenant not to compete. Well, if the court says that that restrictive covenant is violates public policy, or if the geographical restriction is not located, if a non-compete covenant is too restrictive, the court will throw it out and it will say that that contract's violated public policy because people do have a right to work. So, it usually happens when someone leaves company A and goes to work for company B. So if I work for a computer software company and I learn all their trade secrets, their customer information, how they write their codes and all that, and I go to work for company B, I am not allowed to disclose those trade secrets if I've entered into a non-disclosure agreement, or if by law those trade secrets are protected. So a contract that would require me to disclose trade secrets might be one that violates public policy. Any questions about illegal bargains or any ideas of what another illegal contract would be? Okay, so let's talk about licensing statutes. Um, a lot of times, certain professions are regulated by the state. For example, architects and contractors sometimes have to be licensed and bonded to do business in a particular state, like Texas. Texas has a statute that requires contractors to be licensed, architects to be licensed, and if the architect performs work on, say, a construction project, and when it's time for them to collect and they find out that you were not licensed when you worked on that construction project, guess what? They can't get paid. So um, states have licensing statutes that require members of certain professions and occupations to be licensed by the state. Problems arise if an unlicensed person tries to collect payment for services provided to another under the contract. Licensing statutes are enacted to protect the public. They're part of the regulatory scheme. Generally, unlicensed persons cannot recover payments for services that a regulatory statute requires a licensed person to provide. And Trina's friend had an issue. Why don't you tell us about your friend's problem? Do you want to tell us your friend's licensing issue?
Oh, so yeah, my friends, they were building a garage onto their house, and it happened to be like one of their close friends. Like he said he was like he does construction and stuff. So they like started the project, and they said they're gonna come back in a few weeks, and they never came back. So my friend, him and some of his buddies ended up finishing the project, and then he found out that the construction person didn't have a license. So
That's
there's some
terrible.
issues there. So I don't know
Yeah.
what, yeah, I don't know what they're doing. Something got involved with the law, but yeah, he didn't have a license, I guess.
I think what you might be able to do is sue under quantum merit, and I'm not even sure that would work. That quantum merit and unjust enrichment, those are contract theories that simply say, look, I know that this contract can't be enforced, but the owner of this property was unjustly enriched and should pay me restitution for the work that I put into it. So I think the court might allow someone to collect Under a theory of quantum merit, just saying, look, the other person was unjustly enriched because they get to keep all this work that I did on the construction project, and then they're not paying me. And then some courts will say, well, no, you're not going to be able to get around the licensing statutes by changing your legal theory of recovery. So important to know the state law where you're doing business. Just like real estate agents have to be licensed, they have to pass the test and so forth. Unconscionable contracts. What do you think an unconscionable contract is, Stormy?
Sorry, I'm snacking.
That's
Um,
okay.
ones that are not valid because of the terms in them. I don't know specifically, but that's what I would kind of go towards.
That's exactly it. An unconscionable contract is one that shocks the conscience because they're so unfairly oppressive that it just seems unconscionable to enforce. So the general rule, and this is in the Constitution, no state shall impair the obligation of contract. So generally speaking, individuals and companies have the right to contract so long as the object of the contract is lawful and the other elements for the contract are met, offer, acceptance, and consideration, the court will enforce the contract according to its terms. However, some contracts are so oppressive or manifestly unfair that they are unjust. And one that I can think about is there was an issue of a blind consumer purchasing a contract, purchasing a computer. When she got to the checkout stand to pay for it, you know, there was a written disclaimer, saying you have to waive your right to bring a lawsuit if the computer is broken, and you have to agree to binding arbitration. Well, she couldn't see that because she's legally blind. So the court said that it would be unconscionable to hold her to an arbitration agreement, you know, that was on some sort of electronic signature pad when she couldn't see it. And the same thing goes for like some of these rent to own agreements and contracts that have balloon payments in there. If the writing is so tiny that the consumer can't see it, if they're using little tiny font with disclaimers and waivers of rights and your ability to sue, and the court's going to say that's just unconscionable because the consumer is not put on fair notice of these contractual terms, that it would be unconscionable to enforce. Certainly, another example would be, recently with the COVID pandemic, there have been a lot of lawsuits involving Carnival Cruises and other cruise lines for people that got sick while they were on a cruise. Well, of course, what are they going to do when they get back from that cruise? If you get sick on a cruise, what are you going to do when you get back home? What do you think, Stormy? If you get injured on a cruise,
Get in touch with a cruise line and file a complaint or go to the hospital and probably hold them liable for me getting sick on their cruise.
and who's going to represent that injured passenger?
What do you mean? Like you're a personal injury lawyer?
There you go. They're going to call a lawyer, right? So
Hmm.
if somebody has a slip and fall on a cruise, if someone catches COVID on a cruise, if someone gets food poisoning on a cruise, they're going to come back home. If they're smart, they're going to hire a lawyer. And the lawyer is going to bring a personal injury lawsuit against, say, Carnival Cruises, Princess Cruise Line, Norwegian Cruise, whatever. And what the cruise lines have tried to do is go back and look at the ticket and say, oh, there was a waiver of liability provision, on the back of the ticket. Well, the courts have said, first of all, it would be against public policy to tell someone that they are waiving their right to bring a personal injury suit. So when a company tries to waive its own liability for negligence, that's usually void against public policy because it is unconscionable for a cruise line to engage in negligence, like having water on the cabana deck or something, and then have somebody slip and fall and then say, oh, if you look at the back of your ticket, it says you can't sue us. Guess what? That's unconscionable. So taking advantage of consumers is unconscionable. So those are the kind of contracts that would be unconscionable. Because if someone is injured on a cruise ship, they have a cause of action despite what disclaimers may be on the back of their ticket, you know. Any questions about unconscionable contracts? So the legal test for unconscionability is you have to meet a certain number of elements. The following elements must be shown to prove that a contract is unenforceable. One, that the parties possess unequal bargaining power, right? The cruise line has the money. It's got investors. It may be a publicly traded corporation. It has the ability to purchase insurance. The passenger is just somebody who buys the ticket, right? They don't make the policies. They don't decide how often the place is clean. They don't decide who gets tested for COVID. They don't decide how the food is kept. So when the parties possess unequal bargaining power, the dominant party unreasonably used its unequal bargaining power to obtain oppressively or unmanifestly unfair contract terms. They were printed in little tiny words on the back of your cruise ship ticket or in some place where you clicked on the computer and you didn't even see those terms. And the adhering party has no reasonable alternative. So again, if somebody has waived their right to sue for negligence, that might be unconscionable. Any questions about that? Is it clear to you when parties possess unequal bargaining power? Like again, somebody purchasing rent-to-own furniture. I'm purchasing rent-to-own furniture because I need furniture. The furniture store has more money than I do. You know, they've got insurance, they've got investors, they've got underwriters. So the consumer, as it is in a position of unequal bargaining power, right? Because you need that item. And it's the rent to own or the company or store that has the ability to check and make sure the product is safe, to make sure the store is safe, to, you know, regulate the safety in the building and so forth. All right, let's move on to e-contracts in the 21st century. Internet law. The use of the internet and the World Wide Web and the sale of goods and services through e-commerce has exploded. I mean, look at how much richer Jeff Bezos is now than he was in 2019. How much richer is Jeff Bezos, Trina? How much richer is Mark Zuckerberg? All of those people have benefited so much from people being at home, quarantined, and socially distanced in 2020 in particular. Contracts can be created via email. Electronic contracts or e-contracts are made or agreements that are enforceable in court the same way that oral and written contracts are. They don't even require an electronic signature. One of the challenges is determining what the actual terms of the contract are. Sometimes consumers may not even know the seller, right? Have you ever purchased anything on Amazon, Stormy? Have you ever purchased on Amazon or eBay?
You don't even know how much I've purchased on Amazon. It's one of my favorite places to purchase.
Do you know who is selling you the item that you buy?
Not always, no.
No. So yeah, consumers don't even know who the seller is, right? Because all kind of people are listing on Amazon. Sometimes you're buying the actual item from Amazon, but most of the times you're not.
Hmm.
eBay, you've got all kind of sell. I used to sell on stuff on eBay a long time ago. I would buy like t-shirts and things, and I would buy them when they were cheap, and then I would sell them for a lot more online. And no one knew who I was. One time I called my online handle was Kathy's Corner, you know, and I was selling stuff for a lot more than I paid for it. And people on eBay tend to just want to outbid the next person, you know, even if they don't need the item. People start bidding on stuff and they get in these bidding wars and all that benefits the seller. But on the internet, you don't know who you're buying from. So again, it makes it very difficult for consumers to, you know, get fair contractual terms when you don't know who you're buying for. And I made the mistake of purchasing some things on Walmart.com when I thought I was buying from Walmart, but I wasn't. I was buying from a third-party seller who was just listed on Walmart.com, and it was hard to return. So that's why I buy everything on Amazon right now, because all I have to do is go right down the street to Whole Foods or Kohl's and I can return it. Have you had to return anything that you bought on Amazon, Stormy?
Um, I may, yeah, no, actually, no, I've not. I was thinking of Fabletics. I've never had to return anything from Amazon.
Good. They make it very easy um, for the consumer, which is one of the reasons why I don't buy hardly anything else from anybody if it's not on Amazon, because again, Amazon is such a rich, successful company. A few returns are not going to hurt their bottom line. So they have a really easy return policy. I probably return maybe one thing out of 100 that I buy, but all I have to do is take it to the nearest grocery store or the mall, and I do the return online on my phone, and all I do is take the item into the store and say bye, whereas in an era of COVID, it's difficult to return things now at Target and Walmart, and they have different policies, because it used to be very easy to return things at Walmart, but in an era of COVID now it is not as easy. So now I'm just, well, if it's not going to be easy for me to return it, I'm not going to buy it. I'm just going to buy it all on Amazon. So, this explosion of e-commerce has just made Jeff Bezos even more of a billionaire. So let's talk about what warranties are and what warranties you get when you purchase an item, be it online or in a physical store. So a warranty is a promise that a product is fit and will be repaired by the seller or the manufacturer if it is not fit. An express warranty means that the label of the product should say what it is. The product should be what the seller says it is. The law can also imply certain warranties. The implied warranty of fitness for ordinary use. That simply means if you buy a lawnmower, that has the implied warranty of fitness for ordinary use. It does not have to be stated or written. It is implied by law that lawnmower will do what it's expected to do and that it's fit for the ordinary purpose. It also could be called the implied warranty of merchantability. It simply means that the seller guarantees that the product does what it typically does. If it does not, it fails the warranty. So if I buy a lawnmower and it won't cut grass, that's the breach of the implied warranty of fitness for ordinary use, also called a breach of the implied warranty of merchantability. If I buy a microwave and it won't microwave my TV dinners, that's a breach of the implied warranty of fitness for ordinary use. That doesn't have to be written anywhere. It is implied in the law. There's also the implied warranty of fitness for a specific purpose. If the seller has reason to know and understand the purpose of the buyer, if the seller and the buyer are both businesses, a new contract would be made specifying the purpose. So if the buyer tells the seller, look, I'm buying this item and it's to be used in my business for, say, I'm buying this particular dishwasher to use this in my business, and they both know what that specific purpose is, then that would be the implied warranty of fitness for a specific purpose. And the seller had better make sure that that item meets the requirements of that purpose, or that's breach of the warranty of fitness for a specific purpose. And that happens anytime the seller has reason to know and understand the purpose of what the buyer is buying the item for. It's a myth that businesses add warranties. They usually try to limit the warranty so they can't be sued for breach of warranty. This is because the warranties are established by state law. The standard warranties can be excluded or limited unless the limitation is prohibited by consumer protection laws. A business may be able to totally exclude the warranty of merchantability because this is going to limit their risk of a lawsuit in case there's a breach of the warranty of merchantability. Let's look at the UCC provisions. So contracts for the sale of goods, UCC is going to apply. UCC 2-316 requires that an exclusion of the warranty of merchantability has to mention merchantability and be conspicuous. If it is not bold, in caps, with a large typeface, the exclusion of the warranty is not effective. The seller cannot use fine print according to New Jersey Statute 12A, which is their provision of 2-316 in the UCC. So warranties will be tested on your quiz next week, so you want to be sure to complete the knowledge check on warranties. Let's talk about your Module 5 written assignment, which is cheating the elderly. Johanne and Mary are helping their grandfather who has dementia. They want to receive their grandfather Jacob's assets, but they are aware that they may be accused of elder abuse by other family members, so they've asked your supervising attorney to prepare a contract for Jacob to sign. Under this agreement, Johann and Mary, Jacob's grandkids, will do normal weekly housekeeping and look in on him at least 3 times a week in return for the remaining funds payable over a 3-year period. They will not do any personal care for their grandfather, but they will arrange for care as needed. Under this proposed contract, Johann and Mary each receive a salary from their grandfather's Social Security and his 401k earnings, and they also get $50,000 at the end of each year. And if their grandfather outlives his expenses, they plan on him for them to go on Medicaid and assisted living at the state expense. Does this seem like a fair contract to you, Trina?
No, I don't think so.
Unconscionable. So the issues in this case are legal and ethical. Ethical challenges include the role of the attorney. Should the attorney draft this contract? And whether or not Jacob needs his own attorney, right? We've seen that before when a party's unrepresented, you know. Should the attorney let Jacob know, look, your grandkids are trying to come up with this contract where they get all your money for taking care of you, but they've hired an attorney, but do you have an attorney, right? So that's the attorney's obligation. What are some of the other ethical questions? What else is going on here, Stormy?
I would say whether or not he was fit to enter into a contract that had any financial information about his things.
Yeah, it says he has dementia, right?
Mm-hmm.
That means he might lack the capacity to contract. So the first thing you want to do when you're analyzing an issue like this is to do your research. Most of you say you prefer Lexis Advance. So find the very latest, most recent case on Lexis Advance in any state. You're going to use a search for voidable contracts and lack of capacity. You could even look up dementia, incapacity. You want to put voidable contracts in quotes when you do this natural language search so that when they search the cases that those terms are together. Find and cite the most recent available case that's on fast case on contract law and undue influence. So you're going to use fast case for number 2. Use this search or a similar search to get contract law and not criminal law. So you want to search contracts and undue influence. You could also put not crim and use an ampersand after or an asterisk after that, and that means it will not look for criminal cases that talk about undue influence. So we want to look for civil contract cases, not criminal, civil cases on undue influence. That's the search on fast case. Then take a position. What do you think on about the legal and ethical issues presented in this scenario? Support it with your sources, and that means you're going to need to look up the law for incapacity and dementia, the law for undue influence, and also the attorney's ethical obligations when one party lacks mental capacity and one party is unrepresented by counsel. So you're going to do an IRAC. The following two questions are the I. One, is fraud or incapacity involved? And then IRAC that one. Second, if the attorney does the contract and no lawyer reviews it for Jacob, is that unethical under the model rules or the state code, the rules of professional responsibility? Complete the IRAC for these two issues. Use and cite the module readings, the rules of professional conduct, your own moral compass. I would prefer that you use a memorandum format. If it helps you to use a table, do that. Finally, flip it on its other side and say, what would opposing counsel say in response to your position on this scenario about cheating the elderly? Which means argue the other party's side in a paragraph or two. So this should be a fun assignment. Any questions, Stormy or Trina?
No, you answered my question. I was going to ask if we should use the application table, but I think you just answered that for me.
Excellent. Okay, well, it's hard to believe that we've almost reached the end of the term. The Module 5 written assignment is due Sunday, February 6th. The live question this week is, what is the implied warranty of merchantability? Again, Module 6 is very short. It will begin on Monday and it ends on Tuesday. So the live session video will be pre-recorded. I will post it on Sunday to give you more time to watch it. And that'll give you a quiz review for next week. No quiz this week, but for Module 6, you'll have a quiz. Again, winter term 1 ends on Tuesday, because that's the half week of our 5.5 weeks. No assignments can be accepted for a grade after the term ends, unless you have an incomplete grade, due to a medical reason. Any questions? Okay, great. Well, I hope everyone enjoys the rest of your week, and I hope you're very productive and you get everything done by Sunday. Thanks, Stormy. Thanks, Trina.
Oh, I typed it out. Is there a live class code for this one?
Yes. The question is, what is the implied warranty of merchantability? So you just have to answer that question. What is the implied warranty of merchantability? And it simply means that the seller guarantees that the product does what the product normally does, that it's fit for its ordinary use. So the implied warranty of merchantability is the same thing as the implied warranty of fitness. That is your live session question.
Perfect. Thank you.
You're welcome. Thank you, Trina and Stormy, for joining me. Have a great week.
You too. Take care.
Bye. Stay warm.